All right. Thank you very much. And thank you very much, my dear viewers and listeners. My name's Jimmy Agri Simiyu. Simiyu is an advocate of the High Court of Kenya, practicing law in the names and styles of J.S. Simiyu and Company Advocates. My physical address is Gatehouse Building, 5th floor, room 512. We are based along Borogishua Street, Nakuru. And I was saying this particular document helps family members to expedite the distribution of the properties of a deceased person, or rather expedite the distribution of the properties of an estate. Now, if a succession cause is mounted or filed in a court of law where there is no will, it is likely to take time in court, and more specifically, if parties aren't agreeing, or rather if beneficiaries aren't agreeing. But if there is a will and all parties have no objection towards the terms spelled out on the will, then the matter is likely to proceed very fast. Now, just a small point I forgot: when writing a will, the very person who is writing a will also goes with a friend, just to stand with him as a witness, his or her witness. That is equally vital. Now, if this succession cause proceeds without a will, many a time parties disagree on the distribution of properties. On most occasions, men or boys are likely to have a quarrel with their sisters. There's that imagination that the girl child is supposed to inherit from where she got married. But the Constitution, in the eyes of law, a girl child and a boy are equal in the eyes of law. Now, if you disagree on the distribution of property, you are supposed to go to what we call a full hearing of the cause. Now, when you proceed to a full hearing of the cause, we'll have them that we call petitioners, and we'll have them that we call objectors. Petitioners will be saying, this is how we wish this property to be distributed. Objectors will be opposing to the distribution of those properties. Then a third party has to decide, who is a magistrate or a judge or a judicial officer for that matter. And being human beings, one might get dissatisfied with the pronunciation of a judgment upon that distribution of the property. And that's why I'm pointing it out that it is good, if God has helped you acquire some properties, it is good to always reduce it down into writing in the name of a will. Come your demise, your family will not fight or have any hitches towards the distribution of your property. Now, ladies and gentlemen, allow me now to proceed to my topic this evening. And mine is to be a blessing to somebody out there, be an encouragement to somebody out there, enlighten somebody out there, open your eyes. I want to talk tonight about pleadings. My topic is entitled Pleadings. When we talk about pleadings, we are simply, I'm on definition. In simpler terms, or rather in a layman's point of view, pleadings is the manner in which one approaches a court of law. Pleadings are one's prayers, one's desires, one's complaints against a given individual, reduced into writing. So we have around 5 or 6 ways in which one can approach the court of law. Number 1, you can approach a court of law through what we call a plaint. So in Swahili, a plaint is what we call malalamishi, or we can say mashtaka. We have a plaint. Number 2, we have what we call a miscellaneous application. You can approach a court of law through what we call a miscellaneous application. That's number 2. Number 3, you can approach a court of law through what we call a petition. Okay. Then let me go to the plaint, just to not to complicate issues further. Under a plaint, you are narrating your complaint, you are laying out your claim. Now, a plaint has a format. Number 1, you have to give your physical address, your place of abode, your place of residence. Number 2, you have to describe the nature of claim that you're having against a particular person. Now, the person that you are suing, under the civil procedure rules, we call that person a defendant. Okay? Under the Criminal Procedure Act, a defendant is the person we call an accused person. So if you are sued for a claim of on a land matter, the person arraigning you in court is called the plaintiff, and you who is sued is called the defendant. Now, a plaint is also, it also has its limits. There's what we call jurisdiction. For instance, if you did a sale agreement of a subject suit property in Nairobi, then this particular defendant also lives in Nairobi. The land you are fighting over is situated or based in Nairobi, and you live in Nakuru. The law demands that you file your suit or rather claim in Nairobi. Reasons being, the subject land, the subject suit property is situated or rather situate in Nairobi, and equally the defendant, the very person you are seeing, is based in Nairobi. If you sued that person from, or rather in Nakuru, your claim is likely to be struck out. When I say struck out, you are simply saying the court will tell you, we don't have the territorial jurisdiction to hear this claim. You are supposed to take this claim to the right jurisdiction. So it is struck out. So when you hear the term, a suit has been struck out, an application has been struck out, it simply means you have a chance of redoing or moving to the right jurisdiction. Now, under the plaint, you lay your claim, you narrate, you narrow down, you just summarize your claim. Upon summarizing your claim, you will do what you call your statements. Statements backing up your claim. Then you're also supposed to file what we call your list of documents. your list of documents, the documentary evidence, that which you intend to rely upon. If, for instance, it is a claim for money, you have some agreement, you have some checks that bounced or were dishonored, then you're supposed to attach those checks. If it is an employment claim, you're supposed to have a letter exhibiting that indeed you're employed by this particular defendant or you're employed by this particular defendant company. Very, very important. Now, upon mounting or filing a plaint in our courts of law, it is assessed and you're supposed to remit some monies to the court. You're supposed to pay for it. You'll be given what you call a case number. Now, once your plaint is registered, you've gotten what you call a case number. Now you proceed to serve. You proceed to take your pleadings to the defendant. As I said initially, the defendant is the very person you've sued. Now, ideally, you are not supposed to take the plaint in person, just for security purposes. You're supposed to use somebody called a process server. Now, a process server is an officer of the court who has been given the blessing, let me use that word, the blessing to serve court documents. Now, when the process server takes the documents to the defendant, in fact, they're taken, they take two copies. One is yours and the other one is his or hers. That particular defendant is supposed to acknowledge service by signing on the back of the plaint and the summons to enter appearance. Summons to enter appearance are documents saying you've been sued. You have a duration of 2 weeks to enter appearance. When a defendant receives a plaint, this particular defendant has a duration of 2 weeks to enter appearance. The question that follows thereafter is, what happens if a defendant does not enter appearance? If a defendant does not enter appearance, the plaintiff is entitled to go back to court and request for what we call judgment. He's supposed to request an entry of judgment against you. When judgment is entered against you, it's called an ex parte judgment. This particular plaintiff is given what we call a formal proof. Formal proof means this particular plaintiff comes to the court of law to testify in your absence. Now, upon testifying in your absence, that's the time when now the court of law gives a date for judgment. When judgment is now pronounced or entered against you, a document that comes out is called a decree. A decree is a summary of a judgment. In short, a judgment is a narration of what happened and the observation of the court. The court will be saying whether it has allowed your case or it has disallowed your case. Now, that summary of the judgment is what we call a decree. Then an order is a summary of what we call an application. An application are small prayers that are made in the course of proceedings. For instance, if you are to travel from, I'm using what we call a figurative example. If you are to travel from Nakuru to Nairobi, that traveling from Nakuru to Nairobi, that completion of Nakuru, point A Nakuru to point B Nairobi is what we call now a judgment. A summary of what happened on road between Nakuru and Nairobi is what we call a decree. Now, a ruling is what happens between your journey from Nakuru to Nairobi. You might leave Nakuru, reach Naivasha, go for some refreshments, leave Naivasha, we call it sokomjinga, or lare, or there's a place we call, just after Naivasha, we have Kino. After Kino, then we have Limuru. Now, whatever happens in between, should you get a puncher? Should you stop to buy some maize? Now, those things that happen there is what we call a ruling. Now, a summary of that ruling is what we call an order. Are you together? So, a decree is the parent, an order is the child. Okay? Now, what happens in a scenario where the defendant enters appearance in a claim or in a plaint in a court of law? When the defendant enters appearance, this defendant can enter appearance either by himself or herself, or he can enter appearance through a recognized agent in law, whom we call a lawyer or an advocate. The lawyer or the advocate files what we call a memorandum of appearance. Then you are given 2 more weeks to put in what we call a defense. Now, a defense is a response to the claim stipulated or spelled out in the plaint. Now, once the defendant has responded to the plaint, whilst responding to the plaint, he's supposed to also exhibit or rather file list of documents and list of witnesses. If you are filing a list of witnesses, these particular witnesses also need to record statements. Now, once you've done that, a plaint has been filed, a defense has equally been put on the face of the court record, or rather filed. These parties now go to the magistrate or the judicial officer of the judge for what we call a pre-trial conference. Now, what is a pre-trial conference? A pre-trial conference vide Order 11 of the Civil Procedure Acts and Rules. A pre-trial conference simply means parties are sat down. Then you are asked, how many witnesses are you going to call? How do you need an expert witness in this case of yours? Do you have you exchanged all your documents? The plaintiff, from the look of the defense, is there a need to amend your plaint? Do you feel there's something you need to add on? Are there any pending applications in this case? Is this case ripe for hearing? In between, you also asked, are parties willing to give a chance to this case in terms of negotiations? Are you people able to talk out of court? And my viewers, I need to point it out that a court of law is not always the best place to settle our disputes. Also, an out-of-court settlement is equally important. And why I say so is because in a court of law, when a decision is made, one party will always come out celebrating, another party will always come out crying. But when parties sit down to negotiate, the better. Then, my dear listeners, you proceed to what we call the full hearing of the case. Now, what is entailed in the hearing of a case? It is the plaintiff that will always start by testifying. Okay? And the plaintiff can either be representing or rather appearing in person, or the plaintiff can can be represented by a lawyer or an advocate. At this juncture, you need to know the difference between a lawyer and an advocate. A lawyer is anybody who has studied law. An advocate is one that has studied law, 1. 2, an advocate is one that has signed the role of advocates. So basically, if you studied law in our Kenyan universities and you end up not signing the role of advocates, then you are a lawyer. But if you studied law, 1, graduated, 2, proceeded to law school and signed a role of advocate, then you are now an advocate. So not all lawyers are advocates, but all advocates are lawyers. You need to differentiate that, okay? Now, advocates are the ones who are allowed to represent persons or individuals in our courts of law. Then advocates are like drivers. They need to be renewing their practicing certificates every end of the year. Okay? Now, even for them that are drivers, you also have your driving licenses. You also need to be renewing your driving license after a given duration. Now, let me pick a scenario where the plaintiff is represented by an advocate and the defendant is represented by an advocate too. When you proceed to full hearing, the plaintiff is put on dock. The plaintiff is led in what we call exam in chief. When I talk of exam in chief, I'm simply saying the plaintiff now is narrating his story through his advocate. The advocate will ask you simple questions like your names, where you live, what you do for a living, and the kind of claim you are having against the defendant in this case. In a span of 5 or 10 minutes, you narrate your main dispute against this particular plaintiff. Then you also back up your cause or case via documents. Then you finish by telling court the kind of prayers that you want the court to grant you. Okay? Now, upon finishing exam in chief, the defense lawyer subjects you to what we call cross-examination. Now, what is cross-examination? Cross-examination means this particular defense lawyer punches holes in your testimony. This particular defense lawyer discredits your evidence. This particular lawyer tries to tell court whatever you're telling court does not hold water. Whatever you're telling court is not available in the court of law, or whatever story you are availing in court is pure lies, and therefore your case should be dismissed. Now, once the plaintiff has testified in exam, that is, build up his case through his advocate, then had to be subjected to cross-examination, your lawyer again comes, or advocate comes now to re-examine you. What do I mean by re-examination? Re-examination is an act of trying to cover up those holes that have been punched in your evidence by the defense lawyer. Under cross-examination, you might be limited to questions of yes or no. Did you come to your house at 9? Yes or no? Did you issue a bad check, or did you enter an agreement with the plaintiff? Yes or no? When you try to bring in the factor of but, you are told no. So it is at that point in time when this particular plaintiff lawyer tries to tell you, can you now explain what were you telling court? The defense lawyer asked you a particular question and limited you to a yes or no. Now, can you explain there? Or if you are taken to task over a given issue Now you can be asked to explain well. You could have contradicted yourself in terms of dates. You could have contradicted yourself in terms of time. So you're given a chance now to explain yourself. Now, upon re-exam, PW1 is plaintiff witness 1. Now, plaintiff witness 1 is called. The plaintiff has testified. Now, plaintiff witness 1 is called. Again, your witness is taken through the whole process: exam in chief, cross-examination, re-exam. Now, depending on the weight of your case, you might call so many witnesses. But one thing I need you to know is that a case is not determined by the number of witnesses you call. A case is determined by the strength of your evidence through documentary evidence. You need to know this, my dear listeners and viewers, that we have what we call the best evidence rule. The best thumb rule in the law of evidence stipulates that that which is written speaks louder than that which is not written. That is to mean, if you have all the documentary evidence with you, you don't need to call so many witnesses. In fact, you can call 10 witnesses, 20 witnesses, and still lose your case. You can testify alone as a plaintiff and win your case. Now, upon the closure of the plaintiff's case, we now take a date for defense hearing. Why am I using the term we take a date for defense hearing? Because it's not a must that your case is heard on one day and concluded on one day. And also there are a number of cases that are queuing, that are waiting also to, there are a number of people that are also waiting to be heard. And that's why now you have to take a date for defense hearing. Now, during defense hearing again, this time round, the defendant is put on dock, sworn, testifies in chief, subjected to cross-examination, re-examined, okay? Upon being re-examined, the defendant might also call other defense witnesses, also depending on how he or she looks at that case, okay? Now, upon the closure of the defense case, that is the point in time now when all parties have their cases closed. The plaintiff has closed his case, the defendant has closed his case. You proceed to what you call submissions. You equally take a date for what you call submissions. What is submission? Submission is a summary of one's case. The plaintiff will be saying, Your Honor, from the evidence adduced by the plaintiff, from the number of from the witnesses called, from the documents, the documentary evidence placed before the court, and in light of what the defendant has testified, we feel you should allow the plaintiff's case. Now, the defendant equally does submissions, but the law demands that it is the plaintiff that does his or her submissions, serves the defendant with his or her submissions, then the defense does its submissions whilst responding to what the plaintiff has said in their submissions, whilst narrating your story and pleading your claim before court. You are allowed to attach what you call decisions or authorities. What are decisions and what are authorities? Decisions and authorities, now these are judgments that have been delivered by the High Court. If you are doing a case in the High Court, it is advisable you attach decisions from the Court of Appeal. If you are doing a case in the Court of Appeal, you are advised to attach decisions either from the same Court of Appeal or from the Supreme Court. Okay? Now, upon filing of written submissions, parties can either agree on a mentioned date to take a judgment date, or parties can agree to come for what we call highlighting of written submissions. What is highlighting of written submissions? When I talk about highlighting of written submissions, I'm simply talking about a scenario whereby a lawyer or an advocate tries to emphasize or get to remind the court of certain areas, the court to consider certain things. So the court will note down those points that you have highlighted. Then you take what you take a judgment date. Now, when judgment date is given, parties again arraign or avail themselves in court. With technology, you can arraign yourself in court through what you call a virtual session, or you can physically go to court. When judgment is pronounced, that summary of that judgment is what you call a decree. A decree is extracted. The decree can say your claim has succeeded, or the decree can say your claim has not succeeded. Now, your claim can succeed with what we call costs, or your claim cannot succeed, either with costs or no costs, depending on the parties appearing before court. For example, in a divorce cause, the court ideally does not grant costs. Why would the court separate spouses and tell the man to pay the wife ABC amount, or separate the wife and the man and tell the wife to pay the husband ABC amount? No. Now, when talking of costs, we are simply saying this party that arraigned you in court had incurred some expenses. For instance, 1, this party engaged a lawyer. 2, this party took the initiative of trying to track you down. 3, this party paid some fees in court in terms of mounting or filing these particular pleadings. And 4, this party incurred some costs or some interest in terms of the amount of money they're claiming against you. Okay? And also lastly, costs also arise to discourage professional litigants. Let me stress on something called professional litigants. Who are professional litigants? Professional litigants are ni wale watu, let me use some Swahili, wale watu ambao tunaita sumbua. I mean, this is a person who is not able to settle his disputes at home with a neighbor. This person will always want to go to court. Kuku ya jirani imekuja imekula mahindi yako. You feel this is a dispute that cannot be settled pale nyumbani. You feel this is something that needs to go to court. Okay? Ng'ombe ya jirani imekuja imekula nyasi yako kidogo. You feel this is not something to be settled. Umbo ya jirani imeuma ng'ombe yako. You feel this is something that cannot be settled. Kidogo kidogo, you're always running to a lawyer to do demand letters. Now, at times we use costs, okay, for you to know that it's not always good to run to court in the name of suing somebody. Because imagine of a scenario whereby you live in an estate of 50 tenants. Out of those 50 tenants, you have taken 25 of them in court. And out of the 25, you've only managed to win 5 cases. What becomes of the 20 cases? It's good that you are punished by way of paying costs. And once you are punished by way of paying costs, you'll not be a lover of taking people to court. We discourage going to court. The good book says, rather the good book recalls that it's not wise. Always try to, it's not wise. Don't be in a hurry, or don't be in a hurry in terms of taking your good brother to court. Okay? Now, I have covered something little about the claims. Now let me proceed to what we call a petition. Under the petition, the petition is should be divided into three. We have what we call a petition in a divorce cause. If you got married by the wedding, for you to mount a divorce cause, it's mounted or rather filed in court through what we call a petition. So the husband or the wife becomes the petitioner. That means the husband becomes the petitioner, the wife becomes the respondent. Now in a petition, you are simply spelling out what you want against this particular lady. You want the court to declare your marriage as absolutely dissolved. It cannot be reconciled. This particular marriage has become an irresistible demon that cannot be, there's a term we need to use, that cannot be delivered. Okay? So this marriage does not exist. You file it through what you call a petition. If you got married through what we call a traditional or African customary law, then you approach court by way of what you call a plaint. So in a divorce cause or in a marriage where you got married through a church wedding, you go to court by way of what we call a petition. And if you got married traditionally, mulifanya utamaduni zenu, zile mnaita rurasho, then you go with a plaint. Again, you follow the normal procedure: plaint, list of witnesses, documents kama unahitaji. In a divorce cause, documents huwa sana sana: 1, marriage certificate; 2, certificate za kuonesha labda mlibarikiwa na watoto, vitu kama hizo. Okay? Under the divorce cause, kuna ile issue ya what we call distribution of the matrimonial property. Ideally, some courts, and especially Kitambo, you are supposed to do the divorce, then proceed to the distribution of the property. Some courts might do the divorce and at the same time proceed to distribute your properties. How's the distribution of properties done? It's done depending on your contribution towards the property. Initially, it used to be 50-50. Nowadays, it has to be assessed in a way. Okay, it has to be assessed in a way. Now, under petition, pia tuko na kitu inaitwa it's an election petition. Hizi ni kura za governors, hizi ni presidential election, hizi ni kura za members of parliament, hizi ni kura za MCAs. You proceed by what we call a petition. Okay? Then after petition, tuko na ingine inaitwa constitutional reference. Constitutional reference means you feel a particular article or a particular right of yours has been breached and you want compensation. Now, that is or you want an interpretation. You want an interpretation of a given article in the Constitution. You proceed by way of what you call a constitutional reference. Then kuna kitu inaitwa originating summons. Originating summons, you are seeing for what you call adverse possession. You feel umekaa kwa shamba for a duration of 12 years and the law says inakuwa yako because umekaa hapo for 12 years uninterrupted. You can always mount or file what you call an originating summon. Again, the procedure ni ile. You file, serve, give the defendant time or the respondent time to respond, come to court, follow the procedure of compliance. After following the procedure of compliance, proceed to executing or handling your case. Then tuko na kitu kingine inaitwa reference sana sana inakuwa ni these particular parties have costs granted against them, or an advocate has tax some bill against you and you want to challenge this bill. Now you proceed to the High Court by what you call a reference. 5 ways of approaching our courts of law. Now let me mention something important. Under compliance, I have 13 minutes. Compliance is pegged on Order 11 of the Civil Procedure rules. Order 11 was borrowed from we'll call it the European legal system. Huko ni kwa wazungu, developed countries, because in East Africa we use what we call the adversarial legal system. When I talk of the adversarial legal system, it means our cases are more like war in court. Kesi zetu ni za vita kotini. So initially you will file a case, hide your documents, ambush your opponent in court, and you win a case. But now the European legal system has what we call the inquisitorial legal system. Inquisitorial legal system means when parties appear before them, number one, they like to assess these parties. Number two, they like to look at the nature of the dispute before these parties. And number three, they like to give these parties a soft landing. In other words, we'll want parties to come before the temple of justice and come out celebrating. Now, under the inquisitorial legal system is, if parties appear before me as a magistrate or a judge, I look at their documents. If I find the defendant's documents lacking something, or if I find the plaintiff's document wanting something, it is upon me as the judge to tell them, go and rectify point ABC. If, for instance, person A has a claim of 100,000 against person B, and person B has a claim of 50,000 against person A, if now they came to court during the pretrial conference, we'll say, A, you are claiming 100,000 against B. B, you are claiming 50,000 against A. Wacha hizi pesa zikanjane. Let these amounts of money reconcile so that the main dispute ikue, A is claiming 50,000 against B. That is the first phase of approaching the issue. The second phase will be, why can't you people go for what you call mediation? Try and talk it out, try and reconcile, try and settle your dispute out of court. Is the door for reconciliation available? Yes. Now we give them chance to go and talk. Now when they talk, should they agree, they'll come back with what we call a written consent signed by both parties, either through themselves or through their recognized agents who are lawyers or advocates. Then we adopt it as the judgment of the court. Tumemaliza kesi at that phase. Now, under compliance with the adversarial legal system, at most technicalities are employed. Like during our time when we were in college, our lecturer was telling us his pupil master, yule mwenye alimfunza kazi, yeye alikuwa mtu wake wa mkono akimfunza kazi. Once you clear law, unafanya kitu inaitwa pupillage, unakuwa mtu wa mkono wa wakili. So his pupil master mounted an election petition in the High Court. Then he messed by signing it kama petitioner instead of the petitioner signing. So when the case went to court, it was thrown out on those technicalities. That yule ambaye amesign kwa niaba ya mlalamishi, sio mlalamishi, ni wakili wake, which is a mistake. Now the adversarial legal system ilikuwa ina promote, ina encourage hiyo. But the inquisitorial legal system, during pretrial wataangalia waseme, hey, wakili, you signed on behalf of your client. Kindly go amend your petition. Let your client sign. Are you getting it? So the inquisitorial system is more soft in terms of solving disputes. And basically now in Kenya, we are tumeleta pole pole. We've brought it on board and it's helping us solve disputes. Now, when a plaint is filed, a defense is filed, during mediation, you say you want to go to AJS, Alternative Justice System, or ADR, Alternative Dispute Resolution. Parties appear before a mediator. The parties come. In fact, at most parties appear alone before the mediator. Then after some time, parties will appear with their lawyers. They'll sit down. Na pale mtafanya kesi kienyeji, mtaongea kinyumbani, mtajaribu kuelewana. And it's also one of the best way of solving disputes. And in succession matters, inasaidia sana. My dear viewers, inasaidia sana. So never be in a hurry in terms of prosecuting your case in a court of law. Always try to solve or settle it out of court. Inasaidia sana, and it's very, 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 very important. Reasons being, the judicial officers who are judges or magistrates are also human beings, and they are prone to error. Now, if your case goes bad in the subordinate court, before you appeal, your appeal might take time to be heard and determined. Your appeal might equally not go so well. Then you proceed to the Court of Appeal. So before you come to get the true position of your claim, before you come to get justice through appeals, you would have really suffered financially, you would have suffered, and even emotionally, you would have suffered. So we encourage people settling their dispute out of court. Okay? Once you get a judgment and you have a decree, what follows? Once you get a judgment and you have a decree, we move to what we call the execution or execution. The pronunciation is execution stage. A number of us would say execution stage. Now, the execution stage means you want to realize the fruits of your judgment. Ungependa kupata matunda ya uamuzi wako. There are three ways of executing. One, a letter is done to the judgment debtor. Judgment debtor means yule mwenye uamuzi melalia, na mwenye ameshinda kesi anaitwa decree holder. He's told, can you comply with the decree? If, for instance, it is a land matter, na umepata eviction, this particular person is supposed to be evicted. You serve him with the decree. Upon serving him with the decree, depending on the terms of the decree, you have to file an application seeking assistance of the police. Once the police get, I have 4 minutes. Once the police get an order for assisting you, they summon that person, humbly request him to vacate the subject suit's property. If this person refutes or refuses, that's a point in time when now the police use force to evict this person. But also it's equally important to know that there are procedures the security committee follows in terms of evicting somebody. One, they get a court order or a decree. Two, they verify. Why they have to verify is because kuna wasanii wengi sana ukule nje ambao wanaweza jitengeneza fake decrees and orders to come and execute you. Once they are verified, a district security committee sits down to discuss the issue. When discussing the issue, they bring you on board. And when they're discussing, they are looking at a number of options. Is it viable? Is it conducive to evict you? How safe is it to evict you? Because you can evict somebody out of his parcel of land, then you cause chaos. Okay? You cause insecurity. So they look for all all those options. I'm remaining with 3 minutes, my dear viewers. So it is vital. It is vital. It's equally vital. It's equally important to know a way of approaching the court. That's number one. Number two, I'll suggest and I'll advise you always to use an advocate or a lawyer to help you represent yourself in court. It is risky to represent yourself in court. Reasons being, you might not know the loopholes, the procedures, and the games of the rule. Or rather, the rules of the game. You might not know the rules of the game. Okay? So it's important when you have a case in court, always try to engage services of a lawyer. We equally have what we call pro bono services. Pro bono services means there's a form you fill exhibiting your financial status, and you are given an advocate to represent you. I have 2 minutes remaining. So one important groundbreaking statement I need to leave it to you is that a case is won through preparation. A case is won through proper penmanship. If there's poor draftsmanship, poor pleadings, you've done your pleadings in a poor way, this particular magistrate or judge is struggling to hear you, that one might be problematic in terms of you getting justice. Then when you've done your pleadings, you've done your statements, it's important also as a litigant, yule ambaye amepeana hiyo kazi, you go through those papers. Ile kitu ambayo uelewi, unauliza wakili ili akuelekeze, ili akuguide, ndiposa usign. Don't just sign documents blindly. Because you sign blindly during the hearing of your case, the adverse party takes advantage of those mistakes to really corner you, and it can cost your case. I've done exactly, I'm within time. So to that far, thank you very much, my dear viewers, and God bless you. I want to believe and I want to imagine that you have learned something as entertaining. Thank you.